New Jersey traffic tickets with the most serious consequences, Part 2. In a previous video, I dealt with the serious 5-point tickets that if convicted, you would get 5 points for each one of these offenses on your driver's abstract. This is significant because if you get 6 points cumulative total on your abstract or more, you have to pay surcharges once a year for 3 years to the New Jersey Motor Vehicle Commission collection agencies for the privilege of keeping your driving license. And also significant because if you get 12 points cumulative total or more, Motor Vehicle Commission can suspend your driving privileges for a significant period of time. In this particular video, I now want to deal with 3 other very serious municipal court traffic tickets which, if convicted, can result in loss of license for a protracted period of time, high fines, and even jail in some circumstances. So here goes. The 3 are obviously DWI, driving without liability insurance on the vehicle, and driving while suspended, particularly for a disciplinary reason like DWI. Now, in 2 or 3 previous videos, I explained what the consequences are for being convicted of driving your vehicle while impaired, either by intoxicating liquors or hallucinogenic drugs under 39:4-50, and or refusal to take a alcotest test under 39:4-50A. The gist of this is on a first event, it's a 7 to 12 month loss unless your blood alcohol content reading, BAC, is under 0.10, and then it could be a 3-month loss if convicted. On a second event, you can lose your license up to 2 years. There's a provision for minimum 2 days, maximum 90 days jail, which is usually satisfied by giving 30 days of community service. On a third or subsequent event, there's an increased monetary fine of up to $1,500. There's mandatory prison for up to 6 months. Or actually 6 months, 3 months of which can be done in in-house rehab. And then there's a 10-year loss of license for a third or subsequent event. So that's one of these serious tickets. Interestingly, you don't get any points on your abstract for that. You get insurance points, but not motor vehicle points. The same is also true of 39:6B-2, which is operating a vehicle on the public roads in New Jersey without that vehicle having liability insurance. First event, your exposure if convicted is a fine of minimum $300, maximum $1,000, no jail provision, but a loss of license for 1 year. On a second or subsequent event, your exposure is a fine of $5,000, mandatory jail of 14 days, community service of 30 days or up to 30 days, and a 2-year loss or suspension of your driving privileges. Now that's serious, and that's a real imposition. I've had many of these cases. And the way this usually comes up, or has come up a lot, is the defendant's tooling down the road and they don't know that the car in front of them is stopping or turning in front of them, and they don't stop in time and they hit them. They cause an accident. The front bumper of their vehicle strikes another vehicle, either in the back of the bumper of the other vehicle or on the side, or some variation. The police come out to investigate the event, and what happens? They discover this defendant has no liability insurance. So right away that puts you in a tough spot, because the very thing the law is designed to protect the victim against is the very thing that you're violating. You don't have a deep pocket to pay for damages that you caused for the accident. Now, to some extent, how cooperative the victim is does matter. If you, smash up a bumper and it's a $2,500 bill and you pay the $2,500 bill, right away the victim cares less, and you may escape the worst brunt of the law. Oftentimes I've been able to get charges changed from the 6B2 to something different, that you don't lose your license, you don't have terrible fines. So I can help you with something like that. I've done that many times. But it is a serious of type of charge that, if convicted, can cause you all kinds of problems, because we all need to drive in New Jersey, right? And we certainly don't need to be in jail. Secondly, driving without your license, or while your license is suspended or your registration has been revoked. Usually it's for a disciplinary reason, but here's the general schematic. Under 39-340, the gist of this is, first conviction, it's $500 fine, no jail, and up to 6-month loss of license. A lot of times I can get it to 30 days or get it changed altogether or downgraded so there is no suspension. The art of plea bargaining is the art of changing the charges to something less bad. A second event, if you're convicted, it's a $750 fine. It's possible jail, minimum 1 day, maximum 5 days, and up to 180-day loss of license, in addition to the suspension that you already have. On a third or subsequent event, it's a $1,000 fine, minimum 10 days mandatory in the county jail, and up to 6-month loss of license. And it usually is a whole 6 months, because I don't remember that movie Cool Hand Luke, but I call this the Cool Hand Luke scenario, where the warden said to him, what we have here is a failure to communicate. Some people don't want to cooperate, so they're going to let their own. And that's the gist of what they're saying to you. Hey, look, we told you 2 or 3 other times not to drive until you got your license restored. You didn't do it, so now we're not going to cut you any more breaks. Now, that's the threshold baseline 340 law. If the reason you've been suspended is disciplinary, and the most common one is you're suspended for a DWI conviction or a DUI conviction. So that's a situation in which the law has said to you, or the government has said to you, not just, hey, we're suspending your privilege because you didn't pay a parking ticket, or you didn't show up to court, and you didn't pay this other ticket, and it's been a year, so we're suspending your license. This is a situation of saying you may not drive because you are dangerous to other people because you drink. And until you undergo the IDRC, which is Intoxicated Drivers Resource Center evaluation, we're not going to let you drive again because people could die. So if you drive during that circumstance on a first event, it's an additional suspension. I believe it's a year. And there's obviously monetary fine. I believe it's up to $1,500. And then there's jail, minimum 10 days, maximum 90 days. On a second event, it becomes a 4th-degree crime if you only have 1 prior DWI. If you have 1 prior DWI, and that's the one that you're still suspended for and you're driving, you get the 10 to 90. But if you have 2 prior DWIs, and you're driving anyway, even though you're still suspended, it's an automatic 4th-degree crime. Or if you have 1 prior DWI, but you got caught once and you're subject to the 10 to 90, but then you get caught a second time, then it's a 4th-degree crime. Now, the significance of this is it's jail from a minimum 1 year, maximum 18 months, but 6 months of which there's no possibility of parole. You got to do 6 months in the county jail, and you get a felony record for a 4th-degree crime, and you can be fined up to $10,000. Okay, so now this is the extent of seriousness to which the New Jersey legislature is going to show you that you may not drive if you have been suspended for DWI and you've not yet been restored by Motor Vehicle Commission. It's certain jail. So anyway, that's a situation with these cases. I've handled many of them. If you've been charged with any of them, I can help you. They're not the kind of thing you should do alone, because why? Because look at the consequences. And if you don't do them properly and have some luck while you're doing them, you're going to go to jail. So that's not a good thing. My name is Stephen Ankrovat. My telephone number is 732-337-7922. If you've been charged with something like this, give me a call. I'd be happy to help. Thank you.